This is the problem. When you don't adhere to the rule of law and you let politics dictate what you're going to do, you will just make an argument that has no basis in the law. So let's break this down legally. Let's take these issue by issue. Let's start with the question of the National Guard. Now, we have Gavin Newsom, the governor there, suggesting that they don't have the power to bring in the National Guard without the consent of the governor. Let me play actually first a piece of sound. This is number 2 from the California Attorney General there, Rob Bonta. Let's listen.
They unlawfully invoked a law that's intended to prevent an invasion by a foreign nation or a rebellion, or local and state law enforcement make it so that the laws of the United States cannot be executed.
All right. So that seems to apply to both the questions of the Marines, which we'll get to in a moment. But let's start with the question of the National Guard. The governor there has indicated that it requires his consent as a legal matter. Is he right?
I think that's going to be a hard argument for the governor to make here, because what this statute talks about is giving the president the power in a couple of different circumstances. Attorney General Rob Bonta pointed to one of those circumstances, that essentially federal agents can't execute federal law. Another is that there's a time of rebellion or danger of a rebellion, which is exactly what the president pointed to in his memorandum, saying, I want to send in the National Guard. In that particular statute, there's language that says orders have to be issued through the governor. I'm going to offer my interpretation is that orders to call up the National Guard have to be issued through the governor. That's different from saying you need the governor's consent. And if we play this out for a minute, saying that you need the governor's consent would mean that any single governor would have the ability to essentially veto the president using power under this statute. Now, we talked about when this statute has been used before and or when the president has called in the National Guard before. Sometimes it's been in situations where the president has to, for instance, enforce a civil rights decision for desegregation. And there's a governor who says, no, don't do that. So I think we want to be careful to think about not just President Trump, Governor Newsom, but any president and any governor.
So to understand, you said it would have to be done by calling it up through the governor, but not necessarily with the governor's consent. What did you mean by that?
Right. So I'll look at the language here. It talks and says that orders for these purposes, meaning orders where the president federalizes the National Guard, shall be issued through the governors of the state. And that's a quote, shall be issued through the governors of the state. In my mind, that language is different from the president requires the consent of a governor.
So how do you call them up through the governor if the governor won't do it?
So I think what you do is, or it says orders shall be issued through. I think that in my view, a good reading of the statute is to say that it means that you have to give the governor's office notice and that you're hoping that the governor's office would cooperate and issue the orders. But I don't view this as giving a governor a veto power to say, well, I'm not going to issue those orders, and so it's not happening.
But Governor Newsom has suggested he didn't even get the heads up.
That's right. And that's why I think in the California lawsuit against the Trump administration, one of the claims you see here is an Administrative Procedures Act claim, where there's a violation potentially of basically, you didn't give me notice here. And Dan, as you know, we've seen a lot of Administrative Procedures Act allegations, violation of that act, allegations in various arenas dealing with President Trump's executive orders.
This is President Trump in 2020 taking a very different view than the one he is taking now about what happened in Portland. This is number 8.
We can't move in the National Guard. I can call insurrection, but there's no reason to ever do that. Even in a Portland case, we can't call in the National Guard unless we're requested by a governor.
Sounds like the president is taking a different legal position now.
Oh, I don't think it sounds like. I think it absolutely is. I mean, that is a diametrically opposed position. Now, again, I don't think that has legal consequence.
Right.
But obviously, previously he said, yeah, I think I'd have to work with the governor. And let's, of course, be clear that in the vast majority of times, the president does work with the governor. And that, in fact, I think that's legally and politically what we would hope for, that there would be some level of cooperation. But we have had circumstances in our nation's history where the president decides to go it alone. And that's why you see the state pushing back and saying, what about our sovereignty? What about the 10th Amendment? You're infringing on our autonomy here. And the question is how broad of a grant of authority to the president the statute really is.
And you know who's talked about states' rights autonomy is Secretary Kristi Noem. When she wasn't the secretary, she did an interview in 2024, and this is number 10. This is what she said back then.
They were encouraging President Biden to activate our National Guard soldiers so that they would stand down. He actually was going to take control of our South Dakota National Guard and actually activate them so that they would not protect America. So recognizing the real threat that was to states' rights and how that would be the first time in history a president would pay a soldier to not fight, to not protect our country, made me show up in Texas the next day to let Governor Abbott know I'm here. South Dakota is with you. We will defend our Constitution. We will defend our rights, because the last several years we've seen the Democrats take away our freedom of religion, our freedom of assembly, our freedom of speech. We can't let them take away our states' rights, too, especially our right to protect ourselves.
I mean, these hypocrites are just astonishing. Kristi Noem, of course, now taking a completely different position. And this is the problem. When you don't adhere to the rule of law and you let politics dictate what you're going to do, you will just make an argument that has no basis in the law. And that's why we're trying to figure out what exactly is the law in this area. And that is why we're talking to Professor Jessica Levinson from Loyola Law School. All right, let's take issue 2, which is the Marines. The Marines are on standby right now. This seems to me to be a more controversial move, but one in the end. And, I've been reading this Posse Comitatus, Posse Comitatus provision and all the exceptions. And this thing has so many exceptions to it that it seems to me that you can always find an argument to be able to say, oh, well, in this particular case, the Marines could be needed. What's your take?
So my take is you're exactly right. We've got to look at the Posse Comitatus Act. It's a very old statute. And what does it say in brief? It says the president can't order the military to act as a domestic law enforcement agency on U.S. soil. That when it comes to the Marines, when it comes to other members of the Army, when it comes to the Navy, that they cannot act like the LAPD. They cannot act like domestic law enforcement agents unless, and you said there's lots of exceptions, unless there is some, I would offer, pretty extraordinary circumstance. So in what situation would we suspend the protections of the Posse Comitatus Act? One of those examples is when the president pulls a cord and says, I'm using my power under the Insurrection Act. And that would require that a president make a determination that there's some sort of violent uprising or insurrection. The normal channels, the normal mechanisms aren't working. So we have to say we're suspending those protections. And in my view, that would be the most likely route for the president to be able to say that you're calling in the Marines. Now, if I could offer one other thing for us to think about, the president, as we talked about right now for the National Guard, is thinking about and has pointed to Title X. That does allow him to federalize the National Guard, but it doesn't allow the National Guard to do that much. They can act as supporting cast members. They can help federal agents. They can help protect federal property, but they cannot actually be the ones going in and executing search warrants, executing arrest warrants. They are significantly limited because Posse Comitatus still applies. If we move over, Dan, and we're in our second bucket there, and we're talking about using the Insurrection Act, then Posse Comitatus, as we've talked about, then it's suspended. And then you have the National Guard or the Marines acting to directly enforce domestic law on domestic soil. Then they're going in and arresting, then they're searching, then they're seizing. And that is a significant escalation. And I would offer a different world than what we're looking at this moment.
My understanding was that Posse Comitatus doesn't really apply for National Guard, though, does it? I mean, I thought Posse Comitatus was more applicable to, Marines, Army, Air Force, et cetera.
So what I read under Title 10 that the president has pointed to in his memo is saying that he can call in the National Guard, but they are limited. They're limited to that supporting role. And so if you think about Posse Comitatus, if you call in, I view it more as if you call in the National Guard, if you call in the Marines, if you call in the Army, that they can't act to be the people actually doing the arrests until you've suspended Posse Comitatus, until you've said, here's the Insurrection Act.
Right. So at that point, you're saying if the president invokes the Insurrection Act, that at that point, the National Guard can then go about having a broader role.
The National Guard, the Marines, then you have a
everybody.
broader role, period. Exactly.
Right. So it sounds like what you're saying is that Governor Newsom is going to have a tough go at this legally.
So just focused on what the president has pointed to now, Title 10, in my view, there are absolutely others who disagree with me. This particular statute gives the president a lot of authority. I might personally think it doesn't look like a rebellion to me, and I might personally think you really should ask the governor for consent. But I think there's a very fair reading of the statute to say that the president gets to make that call. It
sounds to me like your position, though, is because you can't give the governor effectively a veto power, right, over the president. But when you read the language of the statute, it's kind of tortured to suggest how you get to the president being able to call up the National Guard without the governor. I mean, it sounds like what you're saying is, well, they kind of get to give him a heads up, or they got to let him know, and if they didn't give him a heads up and they didn't let him know, and the language is called up through the governor, seems like it could be a decent argument for Gavin Newsom.
Well, I think that's exactly what Gavin Newsom is arguing here. It's not called up through the governor so much as orders for these purposes are issued through the governor. So meaning, in my view, you're viewing the governor as almost kind of an administrative pass-through. So the president is actually the one who is issuing the orders. The president is the one, it says here, the president may call into federal service members and units of the National Guard. And then the president's order should be issued through the governor. Now, I looked at the suit. I know you've looked at the suit, and the governor is absolutely making the argument that orders issued means just that the governor has power to say, I won't issue the order. I think history and I think practice kind of belies that point.
It's interesting. I think it's going to be look, by the time this works its way through the courts, though, I mean, because where would this be filed? This would be filed in federal court, right?
It was filed
in federal court.
Excuse me. It was filed late last night in the Northern District, because I think, everybody is adept at judge shopping, frankly. And so I believe that the governor knows and is picking a venue that he believes will be favorable to him, as, let's be clear, every governor typically does.
Right. And to be clear, Northern District is a federal court in California that tends to be more liberal. And as a result, he may get a more favorable judgment. But what happens? Okay, let's play this out. So a judge in the Northern District of California says that they don't think that the president has the authority to do what he's done in the way he's done it. And the court orders a pause, right, on it, and tells the president will say, well, I'm appealing immediately. What happens in that interim period?
So he appeals immediately. That word immediately is doing a lot of work, Dan, as you know. He goes to the Ninth Circuit. That is the Court of Appeals that oversees the Northern District in California, and in fact, all of California. And he goes to the Ninth Circuit and says, I know you don't have a minute to read all the briefings, but just pause, meaning stay what the district court did. Just allow me to move forward. Allow me to send in the National Guard. And then we have a question as to whether or not the Ninth Circuit pauses that lower court decision, or if they don't. If they don't, where do you go next? You run to the Supreme Court and you say, I need to get on your emergency docket. I need an answer immediately.
Yeah. All right. We shall see what happens on the legal front. Professor Jessica Levinson from Loyola Law School, thanks so much for coming on the show. Appreciate it.